May it please the Court, my name is Pakita Initial I, appearing on behalf of the defendant, Mr. George Hoffman. I am instructed by the Aboriginal and Torres Strait Islander Legal Service. This is an application pursuant to Section 590, A of the Criminal Code by the applicant for an order that the evidence of all conversations between him and police on 17 August 2019 be excluded. There are two grounds as to why the evidence should be excluded. Firstly, our client was notably intoxicated when questioned by police, and the arresting officers did not allow him time to sober. This is in direct contravention of Section 423 of the Police Powers and Responsibilities Act, for which now I refer to as the PPRA. Secondly, our client was questioned without a support person present and without the notification to legal aid, nor did the arresting officers adhere to the guidelines for questioning Aboriginal suspects. This is in direct contravention of Section 420 of the PPRA and the guidelines. Your Honour, I now submit my first point that Section 423 of the PPRA was directly contravened by the arresting officers. It is clearly evident on the facts that my client was notably intoxicated when police first questioned him at the scene of the crime. This is evidenced by his incoherent manner of speech as well as the distinct smell of alcohol on his breath. Pursuant to Section 423 of the PPRA, police are required to delay questioning a suspect until they are reasonably satisfied the suspect understands and is no longer heavily inebriated. The arresting officers clearly knew that my client was inebriated and thus would likely misunderstand questions and the gravity of the situation. The arresting officers failed to ask a series of basic questions of my client in order to determine his capacity and state of mind, nor did they breathalyze him. Further, the 10-minute transport to the police station, where the officers continued to question him, would not have allowed my client enough time to sober. As such, Your Honour, the arresting officers have blatantly disregarded their responsibilities under the PPRA and continued to question my client whilst intoxicated. As such, I kindly ask that Your Honour, following the decisions in both the Crown and Duggan and the Crown and Martin, use your judicial discretion pursuant to the principles in Bunnings and Cross to exclude the admissions made by my client as a matter of public policy. Your Honour, I now submit my second point that the arresting officers failed to comply with Section 420 of the PPRA and also failed to adhere to strict questioning guidelines for Aboriginal suspects. Your Honour, I start by noting that it is not submitted that my client's responses to police questioning were not voluntary. Rather, the failure of the arresting officers to comply with standard procedure and law with respect to the questioning of Aboriginal people makes the admission of the record of interview into evidence at trial contrary to public policy. For the purposes of my submissions, I rely on the decision handed down in the Crown and Casey. The facts in issue are analogous to the present case, and from which I will draw authority. In the present case, similarly to Casey, the arresting officers failed to contact legal aid once my client was taken into custody. This is in direct contravention of Section 420, subsection 2 of the PPRA. While Section 420, subsection 3 of the PPRA provides that legal aid does not need to be contacted if the arresting officers believe the suspect is not at a disadvantage, it is clear my client is intellectually impaired as well as having cultural communication barriers. This clearly places him at a significant disadvantage in comparison to the general public. Further, while evidence provides the arresting officers asked my client whether he had a support person to contact, his response did not warrant the officers to continue questioning him without a support person present. On the contrary, as was held in Casey, they should have arranged for such a person to be present in accordance with Schedule 9, Section 7 of the Police Powers and Responsibilities Regulations, due to my client's inherent and clear vulnerabilities. Finally, Your Honour, I submit that the arresting officers failed to adhere to and adopt the correct style of questioning that is to be followed when interviewing Aboriginal suspects. This is pursuant to the Queensland Police Service Digital Electronic Recording of Interviews and Evidence Manual. This manual contains provisions from the Inunga Rules, which is the guideline emanated from the decision of the Crown and Inunga and others. The importance of questioning Aboriginal suspects in a manner in which they understand and will respond to truthfully is widely held. It is clear that my client's admission in the recorded interview is gratuitous concurrence. This is clearly highlighted through his nonchalant responses to the officer's direct questioning of his involvement in the break-in. It is clear he is responding in a way in which he believed would allow him to go home, rather than responding truthfully. As such, I kindly ask that Your Honour, following the decision in KC, use your discretion in accordance with the principles in Bunnings and Cross and exclude the video recorded evidence at trial on the basis it would be contrary to public policy. Your Honour, in light of my submissions today, I seek the exclusion of evidence of oral admissions given by my client both at the scene of the crime and at the police station. The arresting officers failed to comply with vital police procedure and the law outlined in the PPRA, and as such, it would be contrary to public policy to encourage and acknowledge such behaviour as valid. Although police enforce the law, they too must ensure they strictly abide by it. Otherwise, justice cannot truly be done. My client's vulnerability as a suspect is clear, and as such, the arresting officers should have taken greater care to ensure my client's comfortability and understanding of the situation in order to protect against unfair disadvantage and discrimination. Thank you for your time today, Your Honour.